Nilashish, this indeed is a historic, decision that the court has taken. So there is some sort of relief coming in when it comes to all those people, who are saying that this is political vendetta. Using sedition is something, is being used as a political ploy. But what happens to those cases who are currently, all those people who are booked under the sedition law? I mean, what kind of relief are we looking at for them, and how can they approach courts for that relief?
Well, as far as the people who have already been slapped with sedition charges, the court has addressed this very clearly. So matters that are pending, in other words, matters where people have already been booked under the sedition law, those cases will be kept in abeyance, which basically means there'll be no trial, there'll be no hearing that takes place in these particular cases till the time the centre, in fact, re-examines and re-looks into Section 124A. In the meantime, of course, the Supreme Court has also said that if there are people who are in jail after having been booked under this particular law, they have the right to approach the appropriate court for bail and seek bail accordingly. Now, the courts must expedite the hearing in this case and decide on the matter expeditiously. So, of course, the process of going to a court is as it has always been the normal procedure of filing an application, and it will be listed before a court at the earliest, and also the case will be taken up expeditiously as per the court's orders that came in today, the interim order that is in place till at least the third week of July, when the centre is expected, to in fact say what the re-examination of 124A could actually look like. Now, other than this, as you also pointed out, moving forward, no case will be registered under 124A by either the centre or any of the states, as has been directed by the Supreme Court. So the court has allowed the centre to, in fact, re-examine this matter, and in the meantime, the sedition law, in a way, has been put on stay, put on hold. Now, the implication also is such that, if we give an example at this point, we know in the Delhi riots case, Sharjeel Imam has been slapped with sedition, and he has his case going on in front of the High Court, where he's seeking bail. Our sources tell us that after this judgment, tomorrow he will be approaching the Delhi High Court with a fresh bail application, citing this judgment, saying, give me an expeditious hearing. Now, as far as this particular law is concerned, we have been speaking to senior advocates, experts on this issue, and what their concern is, and what they have said as far as welcoming this judgment is concerned, this order is concerned, is that the difference between the offence against a government and offence against a state is where the misuse happens, and that is primarily the concern with this particular provision of sedition. So when you use sedition, it is supposedly against the government. When you have been seen to be acting against the government, the sedition law is used, and that is where the misuse comes in, because when you act against the state, there are several provisions in the penal code which in fact address this particular issue. So very significantly, the court also took into account the Attorney General's statement that the manner in which in Maharashtra the Ranas were implicated under the sedition law for reciting or chanting the Hanuman Chalisa, these kinds of cases have come forward where you have seen a state misusing the law to its advantage. So that is the basic contour of this particular sedition law, and that will require re-examining. And in the meanwhile, the entire provision of 124A will be put on hold, will not allow centre or the state to in fact file a case or register any fresh case under it, and those which are pending, there will be no hearing or any trial that will go forward in the meantime till the third week of July.